Well, good morning, everybody. Chip Rooster here, WGN News Now. We are awaiting the official start of court, day 3 of the trial of 2 former DCFS workers, Carlos Acosta and Andrew Polovin. These are 2 men that are facing some charges of child endangerment, among others, related to the 2019 death of a 5-year-old in Crystal Lake. And this all is because they visited his home, or at least Carlos Acosta did, in December of 2018, and yet took no action following some concerning revelations about the state of the home, about some injuries seen on the child. And so it was only just September 2020, I believe, that they were charged in relation to this case. Yep, multiple this case. Yep, multiple felony charges filed September 2020. And so this trial has been 3 years in the making since charges were filed, and more than 4 since the event itself that these charges are stemming from. So we're following it. It's something that we've followed as WGN News since the death happened, or at least since he was discovered in April 2019, to include what happened to his parents. We have that information right now on WGNTV.com. You can catch up on those years of coverage, what happened with that original investigation, the ultimate guilty pleas by his 2 parents, his mother specifically pleading to murder, and the charges that these 2 men face. This is day 3 of the trial, so there's 2 other days. We have some brief recaps up on our website right now as well. We do expect the state to continue presenting their case, and more specifically, their 4th witness, or expert in this case, to retake the stand and continue her testimony. When we ended the day yesterday, the defense was having its chance, its cross-examination with that expert testimony, and that is Carol Ruzicka, who is a retired regional administrator for the Illinois Department of Children and Family Services. And so that is where we believe this will restart at now 9:35, scheduled 9:30. Camera's starting to move. Perhaps we'll have our court here beginning momentarily. I did want to add, what was I going to add? Oh, that yesterday that witness actually, or that expert testimony actually began the afternoon of the first day of Monday, and then yesterday the return to the stand in the afternoon after the defense and the state ironed out some discrepancies. And then today, back to the stand. Not sure how long she'll be up on it, and also not sure when that was the piece. You saw my face. I was trying to remember the one other thing I wanted to say. Typically in a court case, when they start the day, it's not right to testimony or questions being asked. Usually they try to address any outstanding issues. Perhaps a motion is brought up, some just general questions asked either by the judge, the jury — there isn't one in this case, it's a bench trial — or one of the attorneys. So I anticipate that will happen first once it actually begins, and then we'll get back into questioning. So stick along with me here on WGN News Now as we bring you the coverage of this trial live, as much in its entirety as I can. I will say I am planning a pause in the live stream when they take their lunch break, and then we'll restart it in the afternoon. Not the only thing we're live streaming today, though. WGN is also covering the funeral services for a fallen Chicago Fire Department firefighter, Lieutenant Kevin Ward. We expect the services to begin at 11 a.m. Central. We have been live streaming a bit of the procession as he is escorted to the funeral home, though I believe he has arrived at this point. And so you'll be able to catch those actual services on air on WGN Channel 9, as well as online, WGNTV.com, if you also wish to view that live stream. So with that, I'll get my face off this screen, and we will continue. The audio is turned on. We'll turn it over to the court case.
We're back on the record, People versus Acosta and Polovin, and we have our witness here. All right, is there anything we need to discuss before we get back to testimony?
No, please, Judge.
Okay, very good.
So no, nothing discussed. We are jumping right back into testimony. The state's fourth witness, an expert witness, Carol Ruzicka, on the stand. The defense continuing their cross-examination. Seeing Carlos Acosta first, and that is Andrew Polovin. Those are the two defendants in this case. Carlos was the DCFS investigator. Andrew was his supervisor.
Judge, before Ruzicka gets started, just to advise the court, while we were in the hallway, Ms. Ruzicka asked me if she could have some water up on the stand, and I said that I would relay that to your honor.
All right, and that's fine.
It looks like there's one up
And
there.
I see one. Thank you.
Okay, very good. So you understand you're still under oath?
I do.
Very good. Have a seat. And you may proceed.
Thank you, Judge. Ms. Ruzicka, when we left off, we were talking about the lead sheets that you had reviewed for Daniel Nowicki and Drew Freund, correct?
Correct.
There are leads references in the C sequence report for Joanne Cunningham.
There
Is that
are.
correct?
That is
Okay.
correct.
I'm going to direct your attention to that exhibit. It's Exhibit 24.
Okay.
Exhibit 24 is the C sequence report. If you can take a look at that.
Sure.
Can you look at Bates stamp page 178 of the C sequence report?
Sure. I see it.
Do you see at the bottom of the page some references to leads check, leads result, and then a question, non-drug related criminal charges on leads?
Towards the bottom, yes, I do.
And you testified in response to some questions from Mr. Keneally about this part of the report. Do you remember that?
I do.
And specifically, you indicated that the answer to that question, non-drug related criminal charges on leads, the answer no was inconsistent with the information on the leads report. Is that correct?
That I do not remember. I'm sorry.
Would that be your testimony?
I don't remember what I testified to regarding that. I'm sorry.
No, I'm asking,
Oh.
would that be your testimony, that it's inconsistent?
I'd have to refresh my memory and look at Ms. Cunningham's leads again.
Okay. The information that's set forth immediately above that question on page 178 of State's Exhibit 24 is information from the leads report. Is that correct?
It is. It comes from the leads. It does.
Okay. Was that information in the report in December of 2018 or January of 2019?
What do you mean in the report?
Exactly as
What,
it
was
is in
this
this
page?
exhibit.
Th-
Was
This page, you mean?
correct?
Yes. This page was part of the investigation.
Okay. Would you agree with me that immediately above the information leads result positive, it says leads check completed June 23rd, 2019?
Oh, it does. You're right.
June 23rd, 2019 is substantially after
That is
this
correct.
case. Ms. Ruzicka,
I'm
if you
sorry.
can wait until I finish my question.
I'm sorry.
June 23rd, 2019 is substantially after this C-sequence investigation was closed on January 4th, 2019, correct?
That is correct.
And June 23rd, 2019 is after AJ's death, correct?
That would be correct.
So this information cannot be the same information that was contained in the report as of December 2018 or January 2019, right?
I couldn't say if it was or wasn't, though the date reflects June of 2019.
If you can turn back, we had talked about the address information having changed in the report. Can you turn to page 169?
Sure.
In that People's Exhibit 24.
Yes,
At the top of the page, the first subject on that page is Joanne Cunningham. Is that correct?
that's correct.
And it lists some aliases for Joanne, correct?
It does.
One of those aliases is Kelly Rayner, correct? R-A-I-N-E-R?
Correct.
That was the name that she was admitted to the hospital subsequent to AJ's death to have her baby under, correct?
That I don't know.
Well, it certainly wasn't an alias that existed for Joanne Cunningham in December of 2018, was it?
Not that I'm aware of.
And there's a leads report for Joanne contained within this C-sequence investigation, correct?
Correct.
Can you turn to page 201 of the exhibit?
Correct.
This is the leads report for Joanne Cunningham run January of 2019, correct?
Check. Yes,
You previously testified to the contents of this leads report, correct?
I did.
The alias Kelly Rayner does not appear as an alias for Joanne Cunningham in this report, correct?
That is correct.
In fact, the only aliases that appear are Joanne D. Cunningham, Joanne Doris Cunningham, Joanne D. Summercamp, Joanne Doris Summercamp, right?
That is correct.
So this information cannot have been contained within the report in December of 2018 or January of 2019, correct?
This
The
lead-
information Kelly Rayner was a
Oh.
alias.
Correct.
In reviewing that leads report that is contained within the C-sequence report, starting at page 201 of State's Exhibit 24,
Okay.
the leads information that was provided for Joanne Cunningham includes only charges, no convictions. Is that correct?
That is what this reflects. On this page.
The entire leads report is contained, correct?
Yes,
You're familiar with leads reports and you know how to read them, right?
I do.
In reviewing the leads report, isn't it true that the entire report reflects only charges and no convictions?
Can you give me a minute just to review it? Is you go. Okay to go? I mean, if I go? If I look.
Would you agree with me that the entire leads report reflects only charges and no convictions?
No, there are, it says, if you go into the body of it, a couple things she was sentenced to, such as 6 months supervision.
And supervision is not a conviction, isn't that true?
It's a sentence, but perhaps not. I'm not.
You are familiar with leads
I
reports.
am.
That's your testimony, correct?
I am.
And you do know how to read them, is
I
that
do.
correct? And you understand that the leads report reflects charges and convictions, is that right?
That's correct.
And Joanne Cunningham's leads report reflects only charges and no convictions,
That is
correct?
what that page says, yes.
And the substance of the report that goes into the individual charges also reflects no convictions, correct?
That would be correct.
Can you turn to page 183 of the C-sequence report?
Yes,
At the top of the page, you were asked questions about this domestic violence screening, is that right?
correct,
This was the domestic violence screening of Joanne Cunningham, correct?
correct,
The domestic violence screening is one of the required activities in the investigation, is that correct?
correct.
And it was done in this case, is that correct?
Yes, it was.
The specific questions that you were asked about, at least the top of this page, is with respect to the questions about police involvement for domestic violence, and there is a past order of protection. Do you recall that?
That is correct.
The answer given by Ms. Cunningham in response to both questions is no. Is that right?
That is correct.
And it was your testimony that that was inconsistent with the court records
That is
or
correct.
police reports. Is that right?
Yes, that would be correct.
All of the prior domestic violence and order of protection matters that you were asked about were from 2012 and 2013. Is that correct?
That would be correct.
All of the prior domestic violence police reports and the order of protection that you were asked about were from prior to AJ's birth. Is that correct?
The order of protection, yes. If my memory serves me, that would be right. The domestics were before.
All of the domestic violence police reports and the order of protection were prior to AJ's birth.
Again, I believe the domestic, I'd have to refresh my memory on that, but I do know you're correct on the order of protection.
And you know from your review of the C-sequence alone that there was a prior DCFS involvement at the time of AJ's birth, correct?
Correct.
And as a result of that prior involvement, there was an indicated finding and court involvement, correct?
There was.
a juvenile abuse petition was filed and fully adjudicated, correct?
It most likely was a neglect petition.
I apologize, you're right.
Okay.
A neglect petition was filed, was fully adjudicated, and the family participated in juvenile court for a little over 2.5 years. Is that right?
That would be correct.
All of the domestic violence police reports and the order of protection predated that court involvement. Correct?
Yes, if my memory serves me, yes.
That juvenile case was successfully closed and AJ was returned home. Is that correct?
That is correct.
And it was successfully closed because the family completed all of the services, correct?
That's what one would be led to believe.
You would agree with me that Procedures 300 contains no required investigative activity for a search of court records, correct?
I believe, I'd have to refresh my memory, but I believe it does ask for court records.
Where?
You'd have to let me review it. I know it asks for police records, but I'd have to review it.
You talked about yesterday with Mr. Keneally, and we'll get to police records, but I am asking specifically about court records. There are 3 places where there are required investigative activities that are relevant to this case, right? The required investigative activities for all allegations that's contained within Appendix B, correct?
Okay, yes.
The required investigative activities that are contained within Allegation 11, cuts, welts, bruises, correct?
As well as the other allegation that was involved.
I'll get there.
Okay, sorry.
That's the second one, right?
Okay,
And Allegation 82 for dangerous environment, the required investigative activities contained within that section or subsection of Appendix B, correct?
correct.
That's the 3 relevant places where there are mandatory investigative activities. That's been your testimony, right?
Correct. Everything is in procedures.
There is nothing contained within the mandatory investigatory activities in all allegations, Allegation 11, or Allegation 82 that requires a review of court records. Isn't that true?
I would have to review that to comment.
You've been certified as an expert in these procedures, isn't that correct?
That is correct.
And as you sit here, you can't tell me whether it's required?
There, as you said yesterday, if you remember, procedures are really big. There's many, many pages. If you're asking me for a specific line in procedures, I'd have to go back and review it.
I'm not asking you to cite to it. I'm asking you if the procedures require a review of court records.
Again, I would have to review the record.
So as you sit here,
Procedures.
you don't know.
I believe that they do, but I would have to review to be sure.
We'll come back to that when we
Okay.
take a break and you have an opportunity to review.
No problem.
Can you turn to page 185 of the C sequence report, States Exhibit 24?
I have it.
You were asked about this supervisory note yesterday. Do you remember that?
I do.
And you, in response to Mr. Keneally's question, Mr. Acosta took no photographs, correct? Indicated that that was correct. Do you remember that?
That is correct. He didn't.
Pardon me?
He did not. You're correct.
Okay. That's a completely untrue statement, because hadn't you almost immediately before that testimony identified a photograph that Mr. Acosta took and texted to Mr. Polavin?
That, in fact, I don't know that that was Mr. Acosta's photograph or a photograph of what the police had taken.
So you don't know if Mr. Acosta took photographs?
Right. I know for what's reflected in the record, the police photographs. The one that's in the text message you're referring to, I don't know if Mr. Mr. Acosta took that or if that's a copy of the police photograph.
Turn to page 228 of States Exhibit 24, the C sequence investigation.
Correct. Oh, excuse me.
Page 228 and page 229 are 2 pictures of AJ Freund, is that correct?
Mm-hmm.
The picture on page 228 is a picture of AJ's face.
That's correct.
And it indicates face for ID, right?
Correct.
And the picture on page 229 is a picture of the bruise, is that correct?
That's correct.
What reason do you have to believe that these are not pictures taken by Mr. Acosta?
My understanding is they were police pictures taken by the police.
Your understanding from what?
That is what I understood from reading, that these were taken by the police.
From reading what?
Looking at the totality of the pictures, I know the pictures of the home were taken by the police.
I'll get to those pictures.
Oh, okay.
I'm asking specifically about the pictures of AJ on pages 228 and 229. From what in the C-sequence report do you derive that these were not taken by Mr. Acosta?
Because there was nothing to reflect that he took photographs.
You mean there's not a specific line in a narrative, I took photographs?
That is correct.
So you're assuming that he did not take photographs, is that right?
If it's not documented, I cannot say that it occurred.
While you're in that section of the report, pages 224, 225, 226, and 227 are all photographs of the home, is that correct?
That's correct.
And each of these photographs has the photo description, photo taken by CLPD, is that correct?
That's correct.
If you turn to page 189 of the C-sequence report, States Exhibit 24.
Oh, 189.
This is Mr. Acosta's note about his interview of AJ Freund, is that correct?
Correct.
You testified yesterday that you had criticisms about the quality of the note, is that right?
That is correct.
You allege that the note doesn't ask anything specific about the dog, is that right?
No, this is the child's interview. Right.
Let me ask you a more specific
Okay.
question. Mr. Keneally asked you, did Mr. Acosta ask anything specific about the dog? And you said no, right?
Specific, yeah.
And you criticized that the note doesn't reflect that Mr. Acosta used his investigative skills and his clinical skills. That was your testimony yesterday,
That
right?
was, yes.
What clinical skills?
What clinical skills?
Yes.
As an advanced specialist in his position, the expectation and part of the reason he's in that position is with the understanding he has more clinical skills than a number of the other staff. Not everybody's an advanced specialist. So the reasoning would be that as an advanced specialist, he would know how to interview a child to get more in depth about what happened.
That's not a directive in the Procedures 300, correct?
That is not. That's an expectation of his position that he's accepted.
Pardon me?
That's an expectation of the position he's accepted.
Where is
isn't-
that set forth, Ms. Ruzicka?
It's in I believe it's in the personnel. It's in the job description that,
You believe there's some personnel policy that says that he should use clinical skills. Is that your testimony?
what I'm saying is that as an advanced specialist, a position that he chose to obtain, to be, is that part of the job description for that is that he has clinical skills. It will be,
I appreciate your offering that, but my question is very specific. Is it your testimony today that that is contained within some personnel policy or job description?
yes, I believe it is.
It is not contained within the Procedures 300, correct?
That would be correct.
You wrote a written report with respect to this investigation and your expert opinion about it in 2020, correct?
Yes.
And your criticism of Mr. Acosta's interview of AJ in that written report is that it lacks critical thinking on the part of Mr. Acosta. Is that correct?
If I wrote that, that's probably what it says.
Isn't it true that you're basing all of your conclusions about Mr. Acosta's interview from your review of the contact note?
Could you say that again? I'm sorry.
You are basing all of your conclusions about the interview upon your review of the contact note.
Of this note, you're talking specifically to AJ? Yes.
You have no independent knowledge, firsthand knowledge, of what that interview was.
Correct. I was not there.
So you are assuming if something is not specifically transcribed into the contact note, it was not asked or it was not discussed, right?
That is correct.
And that's true of your commentary on every single interview that was done by Mr. Acosta, correct?
Right, and any other investigator, in any other investigation.
If you turn to page 195 of State's Exhibit 24. This is the contact note for Mr. Acosta's interview with Freund and observation of the home on December 19th, 2018. Is that correct?
Correct.
You answered some of Mr. Keneally's questions about whether certain investigation was done with respect to this contact note as, no, it was not done. And you answered some of the questions, it was not reflected in the C sequence. The latter answer is the more accurate answer for everything, right? Because you can't independently testify that something wasn't done. You can only tell us that you don't see it reflected in the investigative report, correct?
That would be true.
Mr. Keneally asked you if Mr. Acosta had investigated if the house had been cleaned up, and you said that he had not. Do you remember that testimony yesterday?
Correct.
Do you see on page 195, in the middle of the contact note, the sentence that starts bedrooms?
Correct.
Bedrooms did appear to have been picked up and were organized. Do you see that?
I do.
Notwithstanding that testimony, you're sticking with the testimony from yesterday that Mr. Acosta did not investigate whether the house had been cleaned up.
That statement to me just says that the bedrooms were picked up. I don't know if it was cleaned from the time of the day before or whatever. It just says the bedrooms were clean, picked up and organized.
So your criticism is based on the fact that Mr. Acosta's note does not explicitly state living room was picked up, dining room was picked up.
Correct. Correct. If the rooms were picked up, it should reflect that, just as it does with the bedroom.
You would agree with me that Mr. Acosta's note makes clear that he reviewed the entire interior of the house, right?
I don't know if he did the whole interior.
Would you agree with me that the contact note specifically describes the condition of the house?
Of the part of the house that he saw. I don't see anything in here to reflect like he went in the basement or anything like that.
The contact note on page 195 of State's Exhibit 24 does specifically refer to the condition of the flooring, correct?
It does.
It specifically refers to the condition of the ceiling, correct?
It does.
It specifically refers to the living room and dining rooms. Is that correct?
Hang on. It does.
It specifically refers to the kitchen.
It does.
In fact, that note says kitchen appeared clean, correct?
That is correct.
It specifically refers to the temperature of the home, correct?
Okay, 1 second. Yes, it does.
It specifically refers to the bedrooms, correct?
It does.
You suggested in your testimony yesterday that Mr. Acosta did not investigate for feces or urine. Do you remember that testimony?
That is correct.
His contact note explicitly states, worker did sense a slight odor of a dog, but did not observe any feces or urine in plain sight. Isn't that true?
In the living
I'm
areas.
just going to object.
Basis?
The basis is, I just asked that you read the full statement, which is, but did not observe any feces or urine in plain sight in the living areas.
Okay, then let's ask the question the way it was put there.
Mr. Acosta's contact note explicitly states, worker did sense a slight odor of a dog, but did not observe any feces or urine in plain sight in the living areas. Is that correct?
That is the statement. That's what he wrote, yes.
You testified that Mr. Acosta did not see the dog yesterday. Is that right?
That's correct.
That's based upon an assumption because the dog is not explicitly referenced in the contact note.
There's no documentation to support that he saw the dog.
My question is really specific. Your testimony that he did not see the dog is based on the fact that you're assuming that from there being no explicit reference to seeing the dog in the report, right?
I'll be honest, I don't assume things. So I have a hard time answering that question.
So then you don't know if he saw the dog, right?
The documentation does not reflect that he saw the dog.
Nowhere in Procedures 300 is there a required contact to see a pet, correct?
No, no. But
Nowhere in the Procedures 300 is there a required activity to see a pet, correct?
correct.
If you turn to page 200 of State's Exhibit 24. You recognize this page?
The waivers? Yes.
This page specifically identifies the waived contacts or contacts determined to be non-applicable. Is that correct?
That's correct.
If you can turn to the prior exhibit in that book, it should be Exhibit 23, the B sequence investigation.
Hang on. Excuse me, it's not labeled as 23, I believe. It should be tabbed, I'm sorry. Am I looking at it wrong? Oh, I just was
This
looking more.
exhibit is Exhibits 22 to
Okay.
24. Would you agree with me?
I would agree, but
Okay. And it could,
see, it's not tabbed. Do you see what I'm saying?
judges, is there another partial for 22 to 24? You start at page 84 and you read to the report starts at page 60.
I have that.
State your exhibits 22 to 24 starts midway through 23. You have 22 in the first 24 pages of 23. Judge, my next line of questioning is with respect to Exhibit 23. Can we take a break so the state can locate Exhibit 23?
Yeah, let me just make sure I don't have it in here. Don't think I do.
That's it.
It's a-
Well, at least that's A.
This is 22. It's not in the binder, that's why.
Okay. Ms. Rosika, I've turned to State's Exhibit 23, the first page, the B sequence investigation. Would you agree with me that's what that report is?
That is.
Can you turn to page 64 of that report?
Yes.
Would you agree with me, pages 64 and 65 contain some subject information for Joanne Cunningham, Andrew Freund Sr., Parker Freund, and Andrew Freund Jr.?
Correct.
And would you agree with me that the contact information, for example, the residence address, has the same inconsistencies as People's Exhibit 24, the C sequence report? Let me be more specific. The mailing address listed for Joanne Cunningham is the jail, right?
It's listed as other address.
And AJ Freund is listed as deceased, right?
Correct.
And Joanne Cunningham has the alias Kelly Rayner, correct?
That name is on there, yes.
So as we did with the C sequence report, you would agree with me that this cannot be a true and accurate copy of the report as it existed in March or April of 2018 when Kathy Gold finalized it, right?
Right, with the names reflected.
Do you have any idea as you sit here what other information has been changed in this report since March or April of 2018?
I would have no idea, but without looking at the original report.
And you have not done that, right?
Looked at the original report?
Compared this to a prior version of the report?
No, I have not.
Mr. Acosta had no role in the March 2018 investigation of Joanne Cunningham, correct?
To my knowledge, you're correct.
You've reviewed the B
Yes.
sequence report, correct?
Yes.
His name is not reflected
That-
in it because
that
he
is
did not
correct.
participate. Ma'am?
Oh, I'm sorry.
Can you wait until I finish my question? Thank you. You've reviewed the report, correct?
Correct.
And Mr. Acosta's name is not reflected in it because he did not participate in that investigation, correct?
Correct.
This is the report that Mr. Acosta conferred with Kathy Gold about during his C sequence investigation. Is that correct?
Correct.
Can you turn to page 63 of that exhibit? Judge, can I have the state's demonstrative exhibit? Thank you. You recall testifying from the state's demonstrative exhibit yesterday, correct?
Is like the procedures and that? Is that when you? I'm
I'll
not
show
sure.
it to you.
Okay.
I've turned to page 54 of the state's demonstrative exhibit.
Yeah,
Do you recognize those Gottlieb medical records?
I do.
And you recall testifying to them yesterday?
I do.
Can you review on page 63 of the B sequence report, the narrative at the top of the page?
Just review it. I'm sorry.
That's the intake narrative at the time the report was made in March of 2018, correct?
The one on page 63?
Correct.
Yeah, that's from the hotline.
And looking at the narrative hotline report on page 63 of State's Exhibit 23, the B sequence investigative report, and the Gottlieb records, pages 54 and 55 of the State's demonstrative exhibit, the Gottlieb medical records, isn't the information in the medical records that Mr. Keneally read to you yesterday exactly what's contained within the narrative hotline report in the B sequence investigation?
There's more in the narrative of the report than here, but this information that's in Gottlieb report is reflected in the narrative.
There's more in the narrative B sequence report than is in the Gottlieb records, correct?
Correct.
You testified yesterday that one way to receive, get that out of your way.
Thank you.
One way to receive or obtain medical records for an investigator is by subpoena. Is that correct?
That is a way you could get them. It's kind of like the last resort.
It's a department subpoena, right?
Yes, it's administrative.
And issuing a department subpoena requires the involvement and approval of the area administrator, correct?
Yes, I believe so, or somebody above at that level.
Not the investigator and not the supervisor.
Right. The supervisor would let the area administrator know.
The procedures also dictate that a subpoena is returnable no less than 10 or 14 days from the institution's receipt of the subpoena, correct?
I believe that's correct.
This is not an immediate process, subpoenaing medical records, right?
No, you're not asking for it like, yeah.
Can you turn to page 79 of the B sequence report, State's Exhibit 23?
I have it.
First, at the bottom of that page, do you see where it says leads check completed, leads result positive?
Yes, I do.
And it indicates the leads check was completed May 3rd, 2019, correct?
That is correct.
Notwithstanding this investigation having been closed May 20th of 2018.
That's correct.
So we know at least this also has been changed in the report, correct?
Yes.
The information contained in the substance abuse evaluations within the B sequence report. Do you remember answering questions for Mr. Keneally yesterday about some of the responses that were given about the substance abuse evaluation?
I'm sorry, could you say that again?
Sure. You're familiar with the substance abuse evaluation that's contained within all of the report?
Correct.
DCFS investigative reports, correct?
Correct.
And the substance abuse evaluation is a mandatory investigative activity for all allegations, correct?
That's correct.
And you testified to the substance abuse evaluation that Mr. Acosta did as part of the C sequence that's contained within the C sequence of Joanne Cunningham, correct?
Correct.
You also testified to the substance abuse evaluation that was done in the B sequence
Correct.
yesterday. You remember that?
I do.
And one of the things that you testified to was that there were inconsistent responses given in the B sequence and the C sequence, right?
Correct.
And that was one of your criticisms yesterday, is that right?
Correct.
In the course of the C sequence investigation, you would agree with me that Mr. Acosta had information from the B sequence and acknowledged Joanne's relapse and her having entered treatment, right?
Could you say that again? I'm sorry.
In the course of his C sequence investigation, Mr. Acosta had information from the B sequence investigation and acknowledged in his C sequence report that Joanne had relapsed and had entered treatment. Isn't that correct?
I don't remember, he didn't document that he reviewed the B. So I don't,
Ms. Rosico, we covered this yesterday, right?
You're going to need to ask a more
I
specific
know
question.
what you mean.
Some of these questions are far too general, and frankly, you're losing me on some of these also.
Do you have Exhibit 24 still? The C
I
sequence
do.
report?
I do.
Can you go back to it and
Yeah.
turn to Mr. Acosta's contact note about speaking with Kathy Gold?
Sure, give me a second.
It's page 197 of State's Exhibit 24.
Okay.
We discussed this contact note yesterday, right?
Correct.
And your testimony was Mr. Acosta's note spoke with prior CPI. She confirmed details of the prior unfounded report. Was not enough confirmation for you that he had reviewed her report, correct?
That is correct.
You said it needs to say reviewed report explicitly.
That is what I testified to, yes.
That's your opinion, right?
That is the practice of the department, as I
That's-
testified to yesterday.
The Procedures 300 do not mandate the language that must be used in a contact note. Isn't that true?
It mandates that it has to be documented, required documentation.
My question is very specific about the writing of the reports. There is nothing in the Procedures 300 that dictates the exact language that has to be used in a contact note. Isn't that true?
That's correct.
But for certain, Mr. Acosta spoke with Kathy Gold, right?
Yes.
And about the B sequence investigation, correct?
Correct.
And acknowledged in this note, mother entered treatment soon after incident.
Right, that's what Piers Miss Gold said. That's his interview with Miss
So
Gold.
you would agree with me that during his C sequence investigation, he had information from Kathy Gold about the B sequence investigation, right?
At least to the extent that mother entered treatment soon after the incident.
You otherwise don't know what information he had because you're only basing your opinions on the substance of the contact note, right?
That's correct. I wasn't
And
there.
it says she confirmed details of the prior unfounded report, but doesn't have a bullet point list of what those details were, so you don't know what details they discussed, right?
That would be true.
And it's your testimony that you don't know that he reviewed the B sequence report, the actual report, because it doesn't say explicitly reviewed report, right?
It's not
Asked and
documented.
answered.
Sustained.
At the time of the C sequence investigation, Mr. Acosta was dealing directly with Joanne Cunningham, right?
I mean, interviewing her? Is that what you mean by dealing directly with her?
Yes.
Yes, that's correct.
So he had an opportunity during that investigation to observe her, correct?
Right.
And there were distinctions between Joanne's behavior and the physical observations of her at the time of the March 2018 B sequence investigation and the December 2018 C sequence investigation, correct?
I'm sorry, say that again.
There were distinctions between Joanne's behavior and the physical observations of her from the March 2018 B sequence investigation and the December 2018 C sequence investigation, correct?
Both reports reflect concerns about her behavior.
The B sequence investigation contains references to fresh track marks on Joanne, correct? And there were no observations of track marks on Joanne in December of 2018, correct?
I'd have to go and look at the narrative of the report.
Is your memory exhausted as to whether there's an indication that she has track marks?
My memory is exhausted.
Would it be refreshed by a review of the C sequence report?
Yes.
Can you turn to the narrative of the C
Sure.
sequence report?
And I'll give the witness leave to do that.
I'm sorry, what?
But you'll ask me next time, I'm
I
sure.
will, Judge.
Thank you.
There is no indication that there were fresh track marks or any track marks on Joanne in December of 2018, correct?
That is correct.
The B sequence investigation indicates that Joanne Cunningham refused drug testing, correct?
That does reflect, yes.
But in the December 2018 investigation, she volunteered for drug testing, both with Mr. Acosta and at the hospital, correct?
That is correct.
Can you turn to page 87 of the B sequence investigation? People's Exhibit 23.
I have,
You reviewed this a little bit yesterday with Mr. Keneally. Pages 87 and 88 are summaries of prior DCFS contacts with Joanne Cunningham. Is that correct?
prior investigations.
And that includes June 7th, 2012 prior DCFS investigation, correct?
That is correct.
And this B sequence report contains a full narrative of the nature of that June 2012 report. Is that correct?
What, June 2000, June, yes.
At the top of page 87,
Yes.
there is a full narrative that describes the nature of the report in June of 2012, correct?
Right, that's the hotline report, yeah.
And it also indicates that ultimately that investigation was unfounded, correct?
It does reflect that.
Page 87 also reflects a December 2012 report. Is that correct?
That's correct.
And this B sequence report at page 87 contains a full narrative of the nature of the report from December 2012, correct?
The narrative of the report reflected here is the hotline report. That's what's reported, the hotline.
Which reflects the nature of the report or concerning behavior that was reported to DCFS,
Right,
right?
it's what initiated the investigation.
And it also indicates that that December 2012 report was ultimately unfounded. Is that correct?
That's correct, yes, that's correct.
On page 88, the B sequence report includes the A sequence to the number that we have associated with Joanne Cunningham, correct?
Correct.
And that's the report that came in at the time of AJ's birth, right?
That is correct.
At the top of page 88, where the summary of the A sequence begins, it has the A sequence number, her name, the date of the report, October 16th, 2013. Is that correct?
That's correct.
Reflects that that report was indicated, right?
Correct.
And says retention 5 years.
Correct.
That means that the report is only contained within the central register for 5 years. Is that right?
The indicated finding is.
This is the report that resulted in full juvenile court involvement, right? This A sequence report?
Which A sequence? You're referring to the
At
birth?
the top of page
The
88,
birth?
the A sequence report resulting from AJ's birth and him being born opiate positive. This is the report that resulted in full juvenile court involvement for the family, right?
Yes, back in 2013.
The B sequence report, can you turn to page 110 of that report? Also contains leads reports for Joanne Cunningham and Drew Freund, correct? Okay. I'm going to go back to procedures 300. We started talking about the investigation. Yep, you can put that to the side.
Okay.
We started talking about the investigation yesterday and the required activities, required contacts, and required documentation involved in investigations, right?
Correct.
Investigations are broken down into those 3 categories of required investigatory steps, right?
Again, which 3 are you referring to?
Contacts, activities, and documentation,
Yes,
right?
it is broken down that way.
And within the Appendix B, under all allegations, there are required contacts, required activities, required documentation, right?
Correct.
And then there's the same set forth under each numbered allegation contained within Appendix B, right?
Which in the specifics, yes.
And there's 2 allegations here, 11 cuts, welts, bruises, and 82 environmental neglect, right?
Correct.
So we went through required contacts yesterday under all allegations. The next thing set forth in Appendix B is required activities, correct?
Correct.
One of the required activities is to review prior indicated and unfounded reports, right?
Correct.
The A sequence, as of December 2018, had been expunged because the 5-year retention period had lapsed, correct?
Yes, but there's still information that's available within the system.
Not the full report, correct?
No. You're correct.
The report had not yet been expunged when Kathy Gold was doing her B sequence investigation, correct?
Yes, you're correct.
And that's how she was able to summarize it, but she noted there was a 5-year retention period, right? That's what we just covered.
Information is available in the computer.
The narrative hotline information,
Correct. The stuff we just went over.
okay. But not the report in December of 2018.
Once it's the retention code, it's taken off the record. Once it's lapsed.
One of the required activities is to observe and photograph the environment. Is that correct?
Correct.
Mr. Acosta did observe the environment on December 19th, correct?
He did.
He did detail in his contact note his visit to the house, correct?
Yes, he did.
He did detail his observations of the environment, correct?
He did.
Your only criticism is that he did not take pictures on that day. Is that correct?
That, and I don't know if he fully reviewed the whole home. I don't know.
There was no reference to the basement in the hotline report, correct?
There were prior concerns. But in the hotline report, no. But as part of reviewing a home, you should see the whole home, not just
Ms. Rosica, when you say there were prior concerns,
noted in police reports.
in the 2012 and 2013 police reports, correct?
2013, yes. Yeah, I would say probably that time frame.
The hotline report didn't contain any information about the basement, right?
It did not.
And you have no idea if Mr. Acosta went into the basement. You only know that the basement wasn't specifically referenced in his contact note,
Right,
correct?
it's not documented.
Isn't it true that the Procedures 300 require that a department-issued camera be used for all photographs?
I believe, if my memory serves me, that when cameras were issued, there were initially only so many per team, and they were available to use. At this time, I can't tell you if that was the practice or if everybody had been issued a camera at that time. I don't know. Back in the day, we had Polaroids.
Ms. Rosica, my question is about the procedures.
Oh, I'm sorry, then.
Isn't it true that the procedures require that only a department-issued camera can be used to
Oh.
take photographs?
Yes, well, yes, but then there, and I can't tell you if it was in a memorandum, a transmittal, or something, that it acknowledged that you could use the camera on your state-issued phones. Because, yeah,
I'm going to hand you Procedures 300. But can I have State's Exhibit 20?
Right in front of you, Rebecca, I think it's down there.
He's right. I'm showing you People's Exhibit 20, which is Procedures 300.
Yep.
Can you please turn to section 300.50, page 9?
I see it.
At the bottom of the page, the first note, under subparagraph I, photographs, note, child protection specialists may only use department-issued cameras when photographing a child during the investigative process.
That is correct.
That's what's contained in the procedures, correct?
And that could also be the camera on the state-issued cell phones.
Okay, which you just indicated you think maybe came out in an email or a memorandum. Was that your
It
testimony?
was accepted practice, I know, I can tell you that. And without going back to see where it was approved, it was acknowledged that was a state-issued cell phone that had, when they gave new phones that had camera capacity, staff were allowed to use those. Those were their cameras.
Ms. Rosica, that's not contained within the Procedures 300, correct?
I don't see where it says it has to be a separate camera, that it couldn't be your state-issued cell phone camera. I'm not saying that.
I'm not asking you that question.
Okay.
There is nothing in the Procedures 300 that says you can use your phone as a camera, right?
There's nothing that says you can't.
One of the required activities under all allegations is a medical examination. Is that
Correct.
right? Specifically, the required activity reflects medical examination must be completed if required for the allegation or if injuries are observed. Is that right?
Say it again, I'm sorry.
A medical examination must be completed if required for the allegation or if injuries are observed.
Correct.
A medical examination was done in this case. Is that correct?
It was.
A medical examination could have been waived in this case. Isn't that correct?
It could have, sure.
There is an entire section in the Procedures 300 that addresses medical requirements, correct?
Correct.
A separate subsection?
Correct.
What subsection is that?
Ooh, I'd have to go back and look. I'm sorry.
You don't know as you sit here.
No, not within all these pages. I'm sorry.
That section, in addition to the all allegations required activities, which provides that the medical examination can be waived, that subsection, which is 300.100,
Okay.
reflects that the medical examination is waivable, correct?
Correct.
300.100, which addresses medical requirements generally, explicitly addresses situations where arrangements are made for a parent to take the child for a medical examination, correct?
Okay, yes.
And there are some specific provisions in 300.100 that address a circumstance where a parent refuses to take the child for a medical exam when they're asked, right?
Correct.
That didn't happen here because Joanne cooperated and took AJ for the examination,
She did take
right?
it.
But the specific section, 300.100, provides that if the child is not at imminent risk and the parents refuse to cooperate, the investigator may not take protective custody and may not observe the child's body, right?
Judge and Counsel, sorry to interrupt. If we're gonna quote the P300s, could we just give a cite so I can keep up?
Please
Sure.
do.
Why don't you turn to 300.100, page 7,
In this
in the
one?
Procedures 300.
Okay. I'm sorry, say it again.
300.100, page 7.
Oops. Okay.
At the top of the page, there's a specific, in fact, bolded note that is the end of 300.100, C3A. That note explicitly provides if the child is not at imminent risk and the parents refuse to cooperate, the child protection specialist may not take protective custody and may not observe the child's body. Is that correct?
That's not the full extent of that paragraph.
No, I'm just reading you the end of that paragraph, right?
That is what the statement in here is.
Yesterday, when you were testifying from the Procedures 300, Mr. Keneally was reading you certain selections of the procedures. Is that correct?
For the most part, yes.
He was not reading the entire selection that you were testifying about, right?
Correct.
Okay. So similarly, I've asked you about a portion of 300.100C3A. Do you agree with me that that's the language contained in that?
That is the statement, yes.
You testified about merit yesterday. Do you remember that testimony?
I do.
If you can keep the procedures in front of you.
Sure.
And turn to 300.100, page 19.
Page, same
19.
section?
Same
19?
section,
19.
page 19.
Hang on. Yes, I have it.
I'm actually going to back you up. Can you
Okay.
look at page 18? At the top of the page, there is an acronym, MPEEC.
Correct.
That was the foundational question that Mr. Keneally asked you about, the Multidisciplinary Pediatric Education and Evaluation Consortium, right?
Correct.
That's not the medical team for the northern region, right?
It is available to them if you need it, but it's all under the same umbrella.
This subsection of 300.100 addresses medical resources, correct?
Correct.
And it's identifying the medical resources available to each region, correct?
Correct.
MPEEC says areas served, Chicago and Cook County for second opinions. Is that correct?
That's what the statement says, but it also serves other areas.
I appreciate that, but my question is
okay.
specific. The procedures explicitly provide MPEEC areas served, Chicago and Cook County for second opinions. Is that correct?
That's what it says here.
Okay. The next page, page 19 of 300.100 addresses merit, MERIT. That's the acronym for the medical team that's available to the northern region, correct?
That is it, yes.
It stands for Medical Evaluation Response Initiative Team, right?
Correct.
And that indicates areas served northern region, correct?
Correct.
The Procedures 300 specifically itemize the kinds of cases that merit are available for. Is that correct?
But not limited to, as it states.
It says cases include but are not limited to, and then it has 3 bullet points, correct?
It does.
Those bullet points are sexual abuse cases, right?
Correct.
Physical abuse cases including head injuries, bone fractures, internal injuries, and burns, right?
Correct.
And the third bullet point, severe neglect cases, right?
Correct.
The page before that addresses MPEEC has its own bullet point list, correct?
Again, but not limited to.
That bullet point list says the identified allegations include, and then has bullet points, right?
Correct.
The bullet points under the different medical team, MPEEC, include allegation 11, cuts, welts, bruises, and abrasions, right?
Correct.
One of the required activities that you can put that to the side for now. One of the required investigative activities that you testified to was other reports, which you characterized as other police reports, right?
Yes,
And you reviewed some with Mr. Keneally, correct?
I did.
There is a separate part. At the time that you were testifying yesterday, you were referring to investigative steps pursuant to Appendix B for all allegations, right?
As well as in the specifics, yes.
Okay. The obligation to get other police reports, you testified, derived from the required investigative activities for all allegations. Is that right?
I believe that's what I testified to, but also in specific ones as well.
There is also a specific direction in 300.50 that addresses police reports. Is that correct? I'm just going to ask you
Oh, okay.
generally for now.
Yes.
And 300.50 defines the investigative process in total, correct?
Yes, it did. It talks about the investigators' activities.
Oh,
Yeah.
It's actually titled investigative process,
It
correct?
is, it is.
And 300.50 is generally applicable to investigators, and 300.70 is generally applicable to supervisors, right?
True.
So 300.50 has some specific investigative direction, correct?
Correct.
And 300.70 has some specific supervisory direction,
That's correct.
Within 300.50, why don't you just turn to it again? Can you look at page 12 of 300.50?
Hang on. I'm sorry, what page again?
Page 12.
I have it.
This is part of the investigation process. This page addresses the investigation process, right?
It does.
And it's got some specific investigatory steps.
Correct.
One of them is requesting the social security number and picture identification from alleged perpetrators, correct?
That's correct.
There was no question that Joanne Cunningham, who was in custody in the police department on December 18th, was in fact Joanne Cunningham, the alleged perpetrator, right?
Yes.
The second part of that subparagraph B, which is actually 300.50 C6B, addresses contacting law enforcement. Would you agree? The second paragraph of subparagraph B at the top of page 12.
It does reflect contact with law enforcement, yes.
And it specifically directs that the child protection specialist shall inquire how long a family has resided in their present address and obtain information, including the address of any previous residents. Contact with law enforcement in cities and towns in which a family recently resided is required, right?
Correct.
All of the information contained in the C-sequence report reflects that the family had been living in Crystal Lake for a long time. Is that
Yes.
correct?
Yeah, that's fair.
Joanne's leads indicates that she'd been living there since at least 2012.
Yes, I would agree.
There's no indication that she's recently lived in Chicago, right?
No.
The B sequence report, Kathy Gold's report from March of 2018, contained a summary of Crystal Lake Police Department contacts for the family. Is that correct?
I do believe so, yes.
In addition to the summary of police contacts, it included a printout of involvement of the family with the Crystal Lake Police Department attached to the report, correct?
I'm not sure what you're referencing, I'm sorry.
Do you have the B sequence still?
I do.
Can you turn to page 94 of that exhibit? I believe that's
In the B.
exhibit 23 of the B, yes.
Okay, I have it.
Page 94 of the B sequence investigation is the summary of the police contacts with Crystal Lake Police Department.
That's what this
right?
note would reflect, yes.
And can you turn to page 133?
Oh, okay.
Pages 133 through 139
Oh,
is a printout from Crystal Lake Police Department of contacts with the family, right?
a lot of it is redacted, but okay.
Would you agree that that's a list of police contacts?
It does list police contacts, yes.
And the B sequence report attaches two Crystal Lake police reports, correct?
Say that again, I'm sorry.
Turn to page 140 of that exhibit.
Okay. Okay.
The B sequence investigative report attaches two Crystal Lake police reports, correct?
It does have police reports, yes.
From your time with DCFS as a supervisor, when you had to fill in as an investigator, as a manager, do you have experience with getting police reports?
I do, or did.
And
Did.
specifically, you have experience with trying to get police reports from Chicago, correct?
I did,
It's extremely difficult to get police reports from Chicago, is that correct?
yes.
sequence report to the side again. We'll go back to the procedures.
Okay.
So we were talking about the required activities for all allegations contained in Appendix B, right?
Correct.
Not all of the required activities are applicable to a given case. Is that fair to say?
That would be correct.
For example, one of the required activities listed under all allegations is obtain medical documentation that the injury will have immediate and/or long-term health effects on the child. If that doesn't apply, that required activity can't be completed. Is that fair to say?
Say it again, I'm sorry.
Yes. Would you prefer to turn to the page?
Sure.
Okay. Appendix B, page 10.
Bear with me. Appendix B, page 10.
The middle of that page starts required activities for all investigations, correct?
Correct.
Turning to the next page, subparagraph G. This is page 11 of Appendix B. Subparagraph G, the required activity is obtain medical documentation that the injury/harm will have immediate and/or long-term health effects on the child, correct?
There's the statement, yes.
Okay. That required activity can't be done in every case, right?
Only if it qualifies.
All of the required activities that are set forth in Appendix B for all allegations are waivable, correct?
Yes, but within specific allegations, there's activities that have to occur. But yes, in this narrative, that's what it says.
As it relates to them being required activities for all allegations, they are all of the required activities are waivable, correct?
Within specific allegations, there are things that are not waivable.
We're going to get to the specific allegations. My question is very specific, and it relates to this portion of the Procedures 300, Appendix B. This part of Appendix B addresses required investigatory steps for all allegations, right?
That is what it's titled.
And under required activities, there is a specific note that a waiver of any of the above requirements must be approved by the supervisor, right?
Or may require approval by the area administrator.
But they
Correct.
are all waivable steps, correct?
A waiver of any of the above requirements. Yes, that's what it states.
So we've been through required contacts and required activities. That leaves required documentation, correct?
Okay.
I'm asking you.
Oh, yes.
That's the third subcategory of the
Yes, I'm sorry.
investigation, correct? And the required documentation largely reiterates the other required investigatory steps. If the contact requirement is law enforcement and the required activity is get police report, the required documentation is the police report, right?
In stating that they've been obtained. And reviewed.
I'm sorry, pardon me?
That they've been obtained and reviewed. It's not just obtaining them, it's reviewing them as well.
But the required documentation step is the actual document, right?
And as well as that it's been reviewed, that's been obtained and reviewed. Because
It's
the
your-
requirement is they have to be reviewed. So just having them in the record doesn't reflect that they were reviewed.
So it's your testimony that the required documentation implies that there is also a requirement that a contact note be created, that the documentation was reviewed.
The requirement is that the reports be obtained and reviewed, not just obtained.
Okay, but my question is different because you said documented that it was reviewed.
Correct.
The documentation, required documentation, is the actual documentation that the investigator or supervisor or worker is required by the procedures to get, right?
They're required to obtain and review.
They're required to obtain the documents and to review the documents.
Right.
Can you turn to allegation 11 in Appendix B?
I have it.
This is the abuse allegation relevant to the C-sequence investigation for cuts, bruises, welts, correct?
One of the allegations.
The other one was a neglect allegation, right?
Yes. Yeah.
So
I'm sorry.
allegation 11 is the abuse allegation relevant to the C-sequence investigation, correct?
Correct.
The required contacts for allegation 11 appear on page 3 of that allegation within the appendix, correct?
That is correct.
And the only additional required contact to the other required contacts for all investigations is subsection A, right?
Say it again, I'm sorry.
There's one additional required contact under allegation 11, correct?
There is, yeah, there's, well, there's an A and a B on this, but yes.
B says a waiver of the above
Correct.
requirements, right?
Correct, correct.
It's not an additional required contact, right?
No, it would be additional, something you'd have to document, yes. Okay.
There is only one additional required contact for allegation 11. Isn't that true?
There is reflected in this, but a supervisor can also request additional activities.
Ms. Rosica, my question is with respect to the Procedures 300. You understand the Procedures 300 is a finite document, right? And you testified from it yesterday.
Right.
The specific procedure for allegation 11 defines the required contacts that must be done in addition to the other ones that are required under Appendix B for all investigations. Isn't that right?
Yes?
And the Procedures 300 contain only one other additional required contact. Isn't that correct?
That's what this page says, yes.
Because that's what the procedures require, correct?
That's what this states.
This being the procedures.
Correct, this page.
Sustained.
And that additional contact is that law enforcement shall be notified verbally and in writing regarding infants under 12 months with bruising, right? All children 24 months and younger with multiple bruises, or when there is a subsequent report on a child 3 years and younger with a previous finding of abuse, correct?
Oh, I see what you're saying. Okay.
None of those were applicable in this case, correct?
Right, the child older than this age.
So pursuant to the Procedures 300, allegation 11, there were no additional required contacts necessary for this investigation, correct?
No, I wouldn't say that. But if you're asking me what that statement says, that is what the statement says.
The procedures don't require any other required contacts for allegation 11, right?
The supervisor can require things of an investigator consistent with procedures.
This is the procedure that you're looking at right now and testifying from, correct?
Right, you're asking me about the specific paragraph. And you're right, the child was older than 12 months or 24 months.
So you're suggesting that outside of what's written in the specific procedure for all investigations or the specific allegations that are at issue, the supervisor could ask for other things?
Yes, depending, like, it's black and white. They could ask for a little bit more than what's just at face value. You know, to further get into the understanding perhaps what happened or whatever.
But the procedures themselves, the specific allegation 11, cuts, welts, bruises, has very specifically delineated required contacts, required activities, and required documentation. Isn't
Right.
that true?
These are minimal. Yes, it's required.
Further down on that page are the required activities, correct?
Correct.
It reiterates a medical examination, correct?
It does.
and specifically provides that the medical examination in an allegation 11 shall not be waived if the child is an infant, is nonverbal, or is developmentally delayed, correct?
Shall not be waived, correct.
But none of those were applicable here, correct?
That is correct.
So the medical examination was waivable in this case, correct?
Yes,
That's the only additional required activity with respect to allegation 11 pursuant to these procedures, correct?
well, it also says that should have done a CANTS 2, which is a body chart.
That's part of subparagraph A, correct?
Correct.
It actually says, should request that the treating physician or nurse complete a diagram, correct?
Correct.
Was there any question in this case about what the AJ's injury was?
Not reflected, but there was no CANTS 2.
My question is very specific. Was there any question in this case about what AJ's injury was?
What? That it was a bruise, you mean?
Correct.
Yes, it was a bruise.
And there was no question about that, right?
Right, as well as he had something on his lip.
And
as
there
well.
are pictures of those injuries, correct?
Correct.
The next part of Procedures 300 Appendix B, Allegation 11, is the required documentation, correct?
Correct.
This same information is contained under Allegation 82, is that correct?
It would be
Addition-
slightly different.
I'm sorry. Under Allegation 82, there is specifically delineated any additional required contacts, activities, and documentation. Is
Yes,
that right?
yes.
Can you turn to Allegation 82 in Appendix B?
I have it.
Each allegation, each numbered allegation, has a specific subsection of Appendix B, correct?
Correct.
The one that you're looking at is for allegation of harm number 82, environmental neglect, correct?
Correct.
It provides a definition of environmental neglect, is that correct?
It does.
And allegation 82 defines environmental neglect. The child's person, clothing, or living conditions are unsanitary to the point there is a likelihood of harm to the child's health, physical well-being, or welfare. This may include, but is not limited to, infestations of rodents, spiders, insects, snakes, human or animal feces, rotten or spoiled food, or rotten or spoiled garbage. Is that correct?
That's correct.
The hotline report contained within the C investigation reports only the condition of the ceiling, the condition of the floor, the kid's bedroom smelling like feces, and dog urine on the floor. Is that correct?
Yes, that's what I believe.
The hotline report did not include any report or indication of infestation of rodents, right?
True.
It did not include or indicate any infestation of spiders, correct?
True.
It did not include or indicate any infestation of insects, correct?
True.
It did not include or suggest there was any infestation of snakes, correct?
Correct.
It did not include or indicate there was any rotten or spoiled food, correct?
Correct.
It did not include or indicate that there was human or animal feces, correct?
No, my understanding was the smell.
It did not include or indicate that there was rotten or spoiled garbage.
Correct.
Right? Allegation 82, if you can turn to, I'm sorry, on the bottom of page 1 of allegation 82, under investigating a report, indicates that there are no additional required contacts for an allegation 82. Is that right?
Correct. Nothing's correct. But
And C-
specifically, well, earlier in the procedures, it does mention that the home environment has to be seen if you have an allegation of 82. But that's
And we specifically address that with respect to all allegations, right?
right. But it does say, especially with relative to this allegation, you have to see the home environment.
And in fact, the home environment in this case was observed by Mr. Acosta, right?
With this, the mandate of, like, for example, on the relative to the 11 allegation, to see the child within 24 hours, if you have an allegation 82, meeting the mandate is also seeing the home within 24 hours.
That's not reflected under allegation 82, investigating a report, required contacts, required activities, or required documentation? Is it?
It's earlier in the procedures.
Ms. Rosika, my question is very specific. You are looking at allegation 82. The mandate that you just referenced is not contained within allegation 82, subsection C, investigating a report, required contacts, required activities, or required documentation, right?
It does not say that on this page, correct?
All right, we're going to take a recess right now. It's 11 o'clock. So everyone be back in 10 minutes, please.
Your dress is pretty.
Thank you. Okay, going back to allegation 82, contained within Appendix B of the Procedures 300, we finished required contacts, we're at required activities, right? At the bottom of that page 1 of allegation 82, it indicates there are no additional activities specific to this allegation, correct?
Correct, that's what the note is here.
That satisfies activities, then we're at required documentation. Can you turn to page 2 of allegation 82?
I'm there.
There are 3 subparagraphs. The last one reflects that they can be waived, right?
Correct.
And the first, under required documentation, is evidence has been documented through observations and photographs that demonstrate that a child's person, clothing, or living conditions are unsanitary to the point there is a likelihood of harm to the child's health, physical well-being, or welfare, correct?
Correct.
If the determination is made by the investigator that the conditions are not unsanitary to the point there is a likelihood of harm to the child's health, physical well-being, or welfare, this required documentation can't be done, right?
Right, if it doesn't exist.
The second required documentation is there has been a thorough identification and documentation of the specific environmental issues that pose harm or significant risk of harm to the child, right?
That's what it says, yes.
Again, if the determination is made that that's not true, can't be done, right?
Correct.
And there are no other additional required documentation investigative activities required for allegation 82.
Not specific, no.
Okay. Before we get out of the investigation and the Appendix B, can you turn back to Appendix B, page 7, which is the investigatory steps or investigation, all allegations.
I'm sorry, tell me again.
Page 7
Uh-huh.
of Appendix B.
Oh, I'm sorry, okay. Hang on. Where it starts, definition of an allegation?
Yes.
Okay.
This is the beginning of subsection H, contacts, activities, and documentation required for all allegations, correct?
That is correct, that's what it says.
And we start with required contacts, correct?
That's correct.
Those required contacts go through page 7, page 8. Can you turn to page 9?
I'm on page 9.
You testified yesterday, I believe, that subparagraph K, the required contact, indicates notify the state's attorney verbally and in writing within 24 hours of the receipt of the report, correct?
That's what it states, yes.
And that's with respect to every report received, every investigation undertaken, right?
Correct.
You are aware that in 2018, the Woodstock Field Office was not daily giving reports to the state's attorney's office of every single report that came in, correct?
Probably, no, they probably weren't doing it daily, correct.
And you, in December of 2018, were overseeing that office as regional supervisor, right?
Right, there was an area administrator there in between. I mean,
In between you and Mr. Polovin, there was an area administrator.
correct.
After an investigation is completed, the final determination has to be made with respect to the report, whether to indicate or unfound. Is that right?
That's ultimately, yes, what is,
And that's done in supervisory consultation by the investigator with his or her supervisor, correct?
that would be correct.
There is a distinction between making a determination to take or maintain protective custody and to indicate or unfound, correct?
Correct, they're two different.
And the Procedures 300 contain different specific criteria for evaluating each of those decisions, correct?
Correct, but one feeds into the other.
There is some overlap between the criteria,
Okay.
correct?
Yeah.
But there are specific provisions in Procedures 300 that identify an itemized criteria or considerations to be made when taking or maintaining protective custody versus a final determination, correct?
Correct.
You were asked about some of the specific provisions yesterday about what to take into account when making the final decision. Don't put that aside too quickly, because I want
Okay.
you to turn to 300.50, page 32.
Wait, 300 point. Tell me again, if you would, please.
300.50, page 32.
I'm there.
This is part of the final determination criteria that's to be taken into account between the child protection specialist and the child protection supervisor, correct?
You're referring to point I.
Subparagraph I, final determination,
Yes.
that starts when the child protection specialist has completed all required investigative contacts and gathered all inculpatory and exculpatory evidence, the child protection specialist shall, in consultation with the child protection supervisor, make a final finding determination, right?
Correct.
And you testified to this process yesterday, correct?
Correct.
There is specific criteria set forth in that subsection directing how that analysis is supposed to go, correct?
In this subsection, but
And there are other subsections that have additional criteria, correct?
correct.
Can you look in Appendix B, page 13?
You want me to hold on to this page?
No.
Okay.
On the middle of that page,
I'm sorry.
subparagraph 4,
What page?
page 13,
13, I'm sorry. I
it's
see
actually subparagraph, the H doesn't appear on this page, but it's Appendix B, subparagraph H4.
Hang on one second. Yep, that's correct.
That subparagraph H4 indicates assessment of factors and evidence to determine a final finding, and indicates 2 additional considerations.
Yes.
correct?
Yes.
Then in Appendix B, under allegation 11, page 4,
Okay.
middle of the page, assessment factors and evidence to determine a final finding.
I see it.
This is specific criteria. Actually, it says factors to be considered include. It's specific criteria for determining a final finding on allegation 11. Is that correct?
Yes, it's factors to be considered.
And if I were to turn to allegation 82, there is a similar subsection that says factors to be considered include, right? It's page 2 of 82.
Yes, I see that.
Okay. There are additional criteria that we haven't looked at just now that include all of the factors that are to be considered and direct critical thinking when making the final determination, correct?
Correct.
All of this direction and the laundry list of factors to be considered, things to be taken into account, weighing the credibility, is because the investigator and the supervisor are charged with making judgment calls, right?
Yes, they are.
About taking protective custody, right? Taking protective custody is a judgment call, correct?
Taking protective custody is a judgment call. Actually, I shouldn't say, well, taking or continuing with it.
That was my next question.
Okay.
Continuing protective custody is a judgment call, correct?
Correct.
Determining whether a report is a good faith report, judgment call, correct?
Correct.
Making the final finding is a judgment call, correct?
Correct. Based on documentation, information, interviews.
When the investigator and the supervisor are staffing or doing the supervisory consult for the final finding, is that usually where waivers were addressed?
It could be early on in the investigation as well.
As investigatory steps were being undertaken?
Right. If, for example, in a case they go out and find out something's not, let me back up. Let's say in an initial supervision note, and I'll just speak in very general terms, a supervisor says to go to do something, then the investigator goes out and finds out, no, it doesn't even apply here. Then the supervisor could go back and like say, no, we're not doing that, I'm waiving that. So at any point through the process, they can do that.
So the waivers could be accomplished all the way from start to finish?
You could do waivers, sure. If it doesn't apply, sure.
Waivers of some investigatory step were common, right?
Some waivers, sure. Yes.
In fact, it was common to have a waiver of at least one investigatory step in every investigation.
I don't know if I would say common, but it was, yeah, I would say it was often, sometimes the case, yes.
You
At least one.
previously testified in this matter in December of 2022, correct?
I did.
And at that time, didn't you testify that you estimated at least 80% of investigations contained at least one waiver?
I would say that's true, yes.
Ultimately, when the supervisor and the investigator make the final determination, that final determination is either indicated or unfounded, correct?
At the end, yes. Ultimately, that's it at the end.
And an indicated finding did not necessarily mean that there would be any additional action, right?
An indicated finding in and of itself, correct.
In a lot of investigations, an indicated finding just means a letter goes out notifying the alleged perpetrator, the now perpetrator, that it's been indicated by the department, and it's reflected in the state central register, correct?
Well, what it really means fundamentally is that it's believed whatever is alleged is in fact true, in fact, and that it occurred. For example,
I'm asking about the practical consequence of the
Oh.
indicated finding, not what it means to the department. The practical consequence of an indicated finding a lot of times was just the issuance of a letter notifying the mandated reporter, anyone else who'd received notification like another parent, and the perpetrator that it had been indicated, and it being reflected on the state central register, right?
there's more to it. In order to indicate a report, you would need to tell the parent that. You just don't send them a letter. I'll use parent, could be guardian, caretaker, whatever. You have to talk to the parent. The investigator has to tell the parent
That they're being indicated.
that they're being indicated and the reasons for it, as well as they should be sharing with them that they have appeal rights. I mean, and again, that should be documented as well.
And then a letter goes out from the department confirming the indicated finding,
It would come out of Springfield.
but nothing else happens. In a lot of cases, that's the end of department involvement. Correct?
Could be. You could also send it for courts. You could indicate it and,
I'm not asking about the other possible things that could
Oh,
happen. I'm saying in a lot of cases, isn't it true that an indicated finding stops there, there's no further action?
I don't know if I would say a lot, but yes, there are cases where that happens, yes.
Do you know how many?
I do not know. There are stats on it that the department maintains, but I don't know.
You're not familiar with them?
I'm not currently, no.
Waivers were common in investigations, at least in part because the case assignments in the Woodstock field office were over mandates, right?
Over mandates, what do you mean by over mandates?
You're aware of the mandates incumbent on the department with respect to case assignments pursuant to a consent decree, correct?
Yeah, I am aware of that.
DCFS is subject to a consent decree, I believe it's commonly known as the BH consent decree.
That's correct.
It entered in the 1990s,
I couldn't tell you that, but it's been a long time, yes.
and it hasn't been lifted because DCFS has never met the mandates, correct?
At least during the time I was employed there, it had not been lifted.
The investigators at the Woodstock field office were over the mandates contained within the consent decree with respect to case assignments, correct?
Yes, most investigators within the department were.
What were the case assignment mandates pursuant to the BH consent decree?
I'll be honest, I don't know if it's, I believe that there were so many months in a year where you could get 12 and then you could get 15. I believe that when I left that was the way it was. But again, I haven't looked at the consent decree in some years, quite a few years.
Do you know how many investigations were allowed annually under the consent decree?
Not off the top of my head.
The consent decree initially was the result of the death of a department-involved child, correct?
I do believe so.
And the consent decree just generally contains certain mandates for the department.
I do believe so. Again, I haven't reviewed that consent decree in many, many years.
Consistently, DCFS has failed to meet those mandates, and that's why it has not been, the consent decree has not been lifted.
I'm really not in a position to respond to that. Again, I haven't looked at the consent decree in many, many years, and I couldn't tell you the reasons why the department, or why it's not been lifted. I don't know.
Do you know how many cases the investigators in the Woodstock field office were receiving per month?
At what point in time?
December of 2018.
Not off the top of my head. I
In
know
2018 generally.
I would say probably 12 to 15.
Per month?
I would probably say on an average, yes.
You previously indicated that you never wanted to have people in their case assignments in the 20s. Is that a fair characterization?
That's fair.
You are familiar with the cases that were assigned to Carlos Acosta, correct?
Familiar, what do you mean by familiar?
I mean, in the course of your work on this case, you obtained specific information about his case assignments in 2018 and 2019, correct?
You mean his case assignment numbers?
Yes.
No.
Didn't you obtain that information while you were working with the Office of the Inspector General?
No, I was only interviewed by the Office of the Inspector General. I never worked with them beyond an interview.
While working for DCFS, it's your testimony that you never requested specifically information for the cases assigned to Carlos Acosta in 2018 and 2019.
I have no memory of doing that.
But you're not testifying that you didn't do it. You're saying you don't remember doing it.
It's a long time ago, and I'm saying I have no memory of having done that.
Okay, but my question was very specific. You're saying you don't remember. You're not saying it did not happen.
I'm saying I don't know.
You specifically, because you were regional manager in this northern region, were aware that the Woodstock field office was routinely over mandates for their case assignments, right?
Every region was, or every office was, for the most part, over their mandates.
And at that time in 2018, Mr. Polovin had reached out to you by email asking for more staff because of how high their case assignments were. Isn't that true?
I couldn't tell you about memo.
Basis?
Hearsay.
Sustained.
Isn't it true that in December of 2018, Carlos Acosta received 20 case assignments?
I would have no idea.
Isn't it true that in January of 2019, Carlos Acosta received 21 case assignments?
I would have no idea.
What is protective action?
I don't know what you mean, protective action.
What does that term mean within the department?
I don't believe that's a term that's in our definitions.
That was my very next question.
Okay.
Is that a term that's defined by the department?
Protective action?
Yes.
Not by definition. I don't believe so.
Is there protective action that is taken by department employees in the course of an investigation?
I don't know how you're defining protective action. I'm sorry.
You're familiar with the process of taking or maintaining protective custody, correct?
I am.
to take or maintain protective custody, there needs to be urgent and immediate necessity to remove the child from his or her home. Is that correct?
Correct, that's the requirement for to move it forward with the court as well.
And you have to demonstrate that no reasonable efforts could have maintained the child in his or her home, correct?
Correct. Or that the situation was such, yes.
There are, much like in making the final determination, there are specific provisions in the Procedures 300 that identify situations where protective custody should be taken, correct?
Yes.
Can you turn back to Procedures 300?
Okay.
300.120.
Yep. I get
This
it.
section, 300.120, addresses taking children into protective custody, correct?
Correct.
And it would be fair to say that these same guidelines and directions relate to maintaining protective custody, correct?
At some level, yeah.
This is the only section of the Procedures 300 that specifically and solely addresses protective custody.
There's other
300.120.
There's other areas where it speaks to protective custody, but this is specific to this, yes.
Can you turn to page 7 of 300.120? This is 300.120 subsection E on page 7 of that section of the procedures, and directs that these are specific instances where protective custody must be taken. Is that correct?
That's correct.
It's titled Immediately Dangerous Situations, Violent Outcomes, Sexual Abuse Circumstances, and Infants 6 months and younger with injury, correct?
Correct.
The specific situations itemized in the procedures here with respect to taking protective custody indicates under subsection E, 1A, immediately dangerous situations, right?
That's what it says, yep.
And then there are subparagraphs that define what those immediately dangerous situations are.
It does.
Subparagraph I, behavior exhibited by a caregiver that indicates he or she is out of touch with reality and that the caregiver's behavior may adversely affect the safety of the child. Paragraph double I, the caregiver demonstrates emotional outbursts and is out of control. III, a caregiver or member of the household exhibits violent behavior and the non-offending caregiver has failed to protect the child. IV, premeditated harm inflicted on the child. V, children age 6 months or younger with an injury. VI, the child is hidden by the caregiver. Or VII, or 7, the caregiver has a contemptuous and or malicious attitude towards the child, correct?
Right, that's what it says.
And these are the specific criteria delineated in the procedures for immediately dangerous situations.
Right, these are ones that, yes, exactly what you said, immediate.
You testified with respect to, can you turn to the C-sequence investigation, States Exhibit 24? You testified to a note related to protective custody contained within the C-sequence yesterday. It's page 172. Can you turn there?
I'm there.
Mr. Keneally, you see at the bottom of the page where it says protective custody?
I do.
And it says PC date 8:30 a.m., PC
Correct.
consult date 8:30 a.m. Mr. Keneally asked you questions about these being the exact same time, correct?
No, I don't think it was this, but I thought it was relative to his interview notes, that the same child was interviewed the same time as mom.
That was different testimony. Do you remember
Okay.
identifying this page of the C-sequence report yesterday?
I do.
Okay. This portion of the C-sequence report was not created by either of the defendants, Mr. Acosta or Mr. Polovin, correct? Does it not indicate it was created by a Jessica Heidenreich?
Right, I'm assuming she was the floor call worker down at the hotline.
So neither of the defendants on trial here had anything to do with this note, correct?
Except for when PC is lapsed, if you see like the fourth line down, that is entered by the field, by either Mr. Acosta or Mr. Polavin. That's entered from the field.
And that line indicates custody lapsed by DCFS, correct?
Right. In the outcome time would be the same time as that. Do you know what I mean?
And it
That would
reflects
be-
the outcome time is 12 PM, correct?
Correct.
Neither Mr. Acosta nor Mr. Polavin input 8:30 AM, correct?
No, that would be from the hotline.
And if you turn to the hotline narrative at the beginning of the report, the hotline call wasn't received till 8:47 AM, correct?
Correct. That would be, but this would be the time that the police took the protective custody. They would, if the police call and say, I took protective custody at 8:30, even if the call was made an hour later, it would reflect when the protective custody was taken.
But it doesn't reflect anything about what Mr. Acosta or Mr. Polavin did, right?
Well, it does at the point of the custody lapse by DCFS in the outcome date and time.
Let me be more specific.
Okay.
The 8:30 AM time doesn't reflect anything about what Mr. Acosta or Mr. Polavin did.
Oh, no.
You identified a text message yesterday between Mr. Acosta and Mr. Polavin. It was State's Exhibit 32. Do you remember that?
I do.
You were asked whether this was an adequate supervisory consult, and you said that it was not. Do you remember that testimony?
Correct.
Is there any indication in the C-sequence report that the text message was a supervisory consult?
No, I don't believe it's documented as such.
There is no reference to a text exchange whatsoever in the C-sequence report. Isn't that correct?
That is correct.
Going back to the protective custody provisions contained within 300.120, you turn to page 2 of that section. This is a subsection of 300.120B, what must be considered in taking protective custody. At the bottom of page 2, which is part of 300.120B3, there is a specific note about at least one thing that's to be taken into consideration. Is that correct?
There's at least one, yeah. There's more than one.
The second note explicitly provides the child protection specialist and child protection supervisor should not base their decision to take protective custody or recommend a final binding determination based on whether non-department professionals did or did not take protective custody of the involved children. Is that correct?
That is correct. The supervisor and investigator decide if the protective custody is going to proceed.
Well, that's actually a critical decision that's made by the supervisor.
Right, but it
correct?
would be in consultation with the investigator.
But my question is specific. The decision is a critical decision that is made by the supervisor, correct?
Right.
You testified yesterday to the use of the CRAP. That's an acronym, CERAP. Is that correct?
Correct.
The CRAP is a safety determination tool.
It
right?
is.
It's used for assessing the potential for moderate to severe harm immediately or in the near future. Is that correct?
Yes.
The definitions contained within the appendix that address the use of the CRAP define certain terms, including immediately or in the near future, right?
Correct.
The appendix, or the definition pursuant to the CRAP of immediately or in the near future is means that an incident can occur now or in the very near future, i.e. before the next time department or contracted child welfare staff see a child, if no protective action is taken to ensure the child's safety. Does that sound right?
Yeah.
There's that term protective action. What does that mean?
Okay. Could you repeat then? I'm sorry.
Immediately or in the near future means that an incident can occur now or in the very near future, i.e. before the next time the department or contracted child welfare staff see a child, if no protective action is taken to ensure the child's safety.
Okay.
What does protective action mean?
It means immediate action to ensure a child's safety.
Would that be protective custody?
It could be a safety plan.
A safety plan is an alternative to protective custody and requires the same showing, right?
What do you mean, same showing?
If there's no urgent and immediate necessity to remove the child, or there are reasonable efforts that can be taken to keep the child in his or her home, there's no need for a safety plan, correct?
Wait, say that again. I'm sorry.
A safety plan is an alternative to protective custody, correct?
Yes.
If there is no urgent and immediate necessity to remove the child, or reasonable efforts can be taken that maintain the child in his or her home, there is no need for a safety plan.
Oh, no, there could be a need for a safety plan. If, for example, it happens after hours or on a weekend and you need more information. So safety plan can be put in place so that further investigation can be done to ensure the child's safety. Sometimes, especially after hours, or I'll say in the middle of the night, you don't have access to the information that you need to totally assess and ensure the child's safety.
So you'd attempt to use a safety plan?
Or you could use protective custody.
Because the safety plan is voluntary, correct?
It is voluntary,
A family can say no.
right. But if the family says no, then the department needs to be prepared to take protective custody.
Okay, so we've talked about protective custody and a safety plan. What other protective action? Or what else is protective action?
Sometimes informal agreements were made with people. That, for example, a parent will stay out of the home.
So a handshake agreement,
Yeah,
completely unenforceable.
yep, yes.
Does it mean anything else, protective action? Is there any other protective action that could be taken?
By the department in and of itself?
Yes.
You could screen a case with court. I mean, there's some further steps you can take. Yeah, there's some things you could do.
From the time of the first CRAP in a case, which pursuant to procedures has to happen within 24 hours, correct?
Within 24 hours of seeing the child victim.
Correct.
But sometimes you may not see the child victim within 24 hours, so
Okay.
it couldn't be done.
The first CRAP is within 24 hours of seeing the child.
Right, or the home environment and an environmental neglect.
And the required contacts dictate that you have to see a child victim within 24 hours of receiving the report, correct?
Or attempt.
Isn't it true that absent a waiver, the next time department staff would see a child is before closing the investigation? A CRAP is required.
No, a CRAP can be done at any time throughout the lifetime of an investigation.
But it's only required to be done within 24 hours of seeing the child victim?
Initially, that's the initial one, correct.
I understand that it can be done at any time. I'm talking about it being required to be done. Absent a waiver, or it coming up at a different time discretionarily, isn't it true that department staff would see a child before closing the investigation?
Should. Yes.
Is that a required activity?
You have to assess the child's safety within, yes, 30 days of closing the investigation, if my memory serves me. Yes.
Can you repeat that?
If my memory serves me, we would be within 30 days of closing an investigation after the child's been seen. I don't know if that came out right, but within 30 days of closing.
The CRAP provisions provide that a child is safe if he's not likely to be moderately or severely harmed immediately or in the near future. That's a definition of safe, right?
Yeah.
Isn't the primary purpose of the CRAP to immediately control the situation to prevent harm from occurring in the short term?
A CRAP is assessing the safety at that point. Just at that point. And it's also assessing the child's safety in the home environment. Or the assessment should be of the home environment. Do
The
you know what I mean?
department makes a distinction between safety and risk, right?
It does. Mhm.
Safety is short-term, immediate, correct?
Correct. That's correct.
And risk is a longer-term threat that specifically in the procedures, they refer to a child may be at risk months into the future.
Sure, that is correct.
The evaluation or analysis throughout the entire investigation, both at the time that you're considering protective custody and or at the time that you're considering a final determination, is with respect to minimal parenting standards, right?
If you're looking at protective custody, you're looking at urgent, immediate. I mean, there's something that has to be done now.
I understand that, and we
Okay.
talked about that's actually a requirement. It has to be
Right.
urgent and immediate.
Right.
But the analysis is based on minimum parenting standards. Is that perfect parenting standards, right?
The department's position is, yeah, you could, it is minimum parenting standards.
It's not great parenting you're looking for. It's minimum parenting standards, correct?
Yes, as it affects the child's safety.
The procedures and the CRAP, none of them requires no substance abuse, right?
Oh, you mean like,
By a parent
Like-
or caregiver.
like, no, you mean like no substance abuse?
No substance abuse.
Yeah, correct.
The definitions require only substance abuse severe enough to threaten child safety, right?
Right, it's all tied to child safety, correct.
Some substance abuse does not equate to there's an issue of child safety,
It could, as it affects their ability to parent.
but it doesn't necessarily.
No, that's where a professional could assess.
And the procedures and the CRAP protocol specifically indicate that safety threats can be mitigated.
They can.
One of the mitigations identified in the procedures and the CRAP protocol is that a caregiver acting on their own initiative is taking reasonable actions to correct dangerous behaviors, right?
That's what it says, yes.
The C-sequence investigation, if you can turn back to State's Exhibit 24,
Okay,
the ultimate finding in that investigation, turn to page 198, because I believe that's where you were when you were testifying to it.
okay,
This is the supervisory note about the final determination, correct?
that's correct.
And page 198, the supervisory note, you read through it yesterday
I did.
and said that you believe that it was unfounded because the medical examination was inconclusive and what AJ said. Was that your testimony?
Yes,
The procedures, we talked about all the criteria that are contained in the procedures and the factors that are to be considered.
correct.
Are you saying that none of those factors were considered when making the ultimate conclusion in this case?
I don't know from the way the note is written.
You would agree that pursuant to the procedures and the criteria that are itemized in a lot of sections of the procedures, it's a totality of the circumstances review when making the final determination, correct?
Right, you look at the whole thing.
When considering the whole thing, one of the things that you're supposed to take into account is the credibility of the people who were interviewed, correct?
That's correct.
And there are specific provisions in the procedures about weighing the credibility, right?
Correct,
You testified yesterday to assessing the credibility of a child.
correct.
Can you look under 300.50, the investigation process, page 28?
I hit page 28.
This is part of 300.50 F4B at the top of page 28, correct?
Hang on one second. That's correct.
It's a subsection of factors affecting credibility of evidence obtained from children, assessing the child's credibility, and the child's account of the facts, right?
Wait,
I was reading the headers of the section.
oh, okay, yeah.
You testified to a part of this subparagraph B at the top of page 28, but didn't address the next paragraph. Doesn't the next paragraph of this provision explicitly provide that child protection staff shall not use their belief that a parent or other person is influencing, coaching, or pressuring a child to make a specific statement during the course of a child abuse or neglect investigation as the basis for indicating an allegation of child abuse or neglect? That is the first part of the second paragraph of subparagraph B, correct?
That's the way it's written.
And you testified that there was some information that AJ's story was influenced, is that right?
There was, right, based on the medical assessment and the statements made from the hospital at that time, or documented by them.
What about the medical assessment suggested that AJ's story was being influenced?
Oh, influenced?
Correct.
It would be implied in the fact that he changed his story that it could have been influenced.
You understand from your review of the case materials that AJ gave different versions of the story to several different people through the course of the investigation, correct?
He did.
And that he reported some version of he was injured by the dog to his mother, to the police officer, to the nurse, to the doctor, to Mr. Acosta. Then he told the doctor, he made some other statements that I don't have in front of me and I'm not
Sure.
going to try and quote.
Sure.
And then he went back to the dog must have done it, right?
Correct.
What indication do you have anywhere in the C-sequence report that someone influenced his statement?
I'm trying to remember the words in there. Again, it would be, you would question it relative to his statement of, if I'm correct, that mommy didn't mean to do it or something to that effect. That would cause one to question, had the child been influenced by somebody? Was he told to maybe not tell? Statements like that should cause one to question.
Same page, page 28 of 300.50, subsection G.
Okay?
This is assessment of case information and evidence, correct?
Correct.
The note contained midway through subparagraph G specifically indicates the decision to indicate or unfound an investigation should not be based on whether law enforcement or a medical doctor took protective custody, correct?
Correct.
You testified yesterday about service referrals. Do you remember that testimony?
Excuse me, I do.
Service referrals are specifically addressed within the Procedures 300 at section 300.130, correct? And 300.130 breaks down at least 3 times when service referrals can be made: during the investigation, at an indicated finding, or at an unfounded determination, correct?
Right, at any point.
All service referrals at any 3 of those stages are voluntary, right?
Initially, yes, they are, unless they're court ordered.
But that's not my question. My question is with respect to those 3 stages. So let's take them individually. A service referral during a pending investigation is voluntary, correct?
Parents have a right to refuse.
And
Or I'll say parents or whoever.
parents or caregivers
Yeah.
have a right to refuse,
Yeah.
correct?
Correct.
And 300.130A3, it's on page 2 of that subsection, specifically indicates the family's willingness to accept services while the investigation is pending is voluntary and shall not be considered in making a determination to indicate or unfound. Correct? That's the last sentence of that subparagraph 3.
I see it, yes.
And subparagraph 3 addresses service referrals during an investigation, correct?
Correct.
Turning back to page 1. Subparagraph 2 reflects service referrals when a report has been recommended for a indicated finding. Is that correct?
That's correct.
Still voluntary, even if the report has been indicated, correct?
Initially, yes.
And at the top of the next page, under 300.130A2A, it reflects, if the family agrees to accept intact family services, the specialist will complete all case opening activities, correct?
You're talking the top paragraph? Yes.
Correct.
Yes.
And then finally, subparagraph 1 addresses service referrals when a report has been unfounded. That's 300.130A1. Back on page 1 of 300.130.
I see. Yeah.
Service referrals where there is a final determination unfounded require the approval of the area administrator, correct?
That is correct.
And the statewide intact family services administrator, correct?
That's correct.
And are voluntary and can be refused by the family.
Correct.
Department-involved children can and are killed by their parents or caregivers, correct?
Children involved with the department?
Yes.
Yeah, children are killed.
And the Office of the Inspector General, or the OIG, investigates child deaths for department-involved families, right?
They did. That was one of their functions. I can only speak to when I was there.
In December of 2018 and January of
Yeah.
2019, the
Yeah.
OIG investigated child deaths of families that were department involved, right?
Or had prior contact.
Within the last 12 months.
I believe that was true, but there also could be exceptions. There were exceptions when they would
And-
review other cases as well.
Okay. Those child deaths of department-involved children happen at every stage of the department process, correct?
Child deaths?
Yes.
Oh, sure, can happen at any time.
So children who are in protective custody, who are in care, are killed.
Unfortunately, yes.
And children who are in open intact cases, or open intact case involved families, are killed.
You mean with the department?
Yes.
Or contracted agency? Yes, unfortunately.
And closed intact services cases. Children involved in those kinds of department investigations or closed intact cases are killed.
Unfortunately.
In fiscal year 2019, which includes the period December 2018 and January 2019, isn't it true that there were 123 child deaths of department-involved children and only AJs resulted in the criminal prosecution of department employees?
I would have no idea.
Sustained.
Yeah,
You reviewed your resume with us when you first started testifying a couple of days ago.
yes.
When did you leave DCFS?
2019. I believe it was August. Could have been September, but I believe it was August 2019.
And you resigned?
I retired.
You're here as the paid expert for the state, is that right?
I hope so. I mean, I haven't been compensated, if that's what you're asking.
You did provide an invoice to the state for your services, did you not?
Previously. Oh, I thought you were speaking about now. No, previously I did, yes, but I haven't for now.
So let me re-ask my question.
Okay.
You are here as a paid expert for the state, correct?
I was paid previously by the state and hope to
You
be paid.
issued an invoice to the state in May 3rd of 2021
Correct,
for $7,850.
correct.
That invoice was paid.
That was paid, yes, it was.
Your invoice from May of 2021 is broken into categories of activities, correct?
I do believe so.
It reflects report completion, requested revisions, and requested edits and revisions. Is that right? Does that sound right?
That sounds right, yes.
How many reports did you write?
Ultimately, I mean, there was one final report. I couldn't tell you how many times. I did it many times and revised it many times. So I couldn't give you an exact number.
How many total reports would you estimate that you wrote and shared with the state?
Oh, I'll be honest, I really couldn't. There would, see, it was never a completed product until the end. It was sort of a work in progress. So
Your invoice reflects 3 different entries under requested report
Right.
revisions. Does that,
3 entries?
3 entries?
Is it-
3
is it-
date entries.
Oh, that's me. That's my time of working on it.
So does that mean that you had written 3 iterations and revised it
3 different times? No, it probably, without looking at it, probably reflects the time I spent doing it. You know, if I spent 3 hours one day, spent 3 hours, picked it up again, continued with it the next.
You have a second subcategory, requested edits and revisions, with 2 specific date entries.
That's probably, again, when I was working on that. And those were clarifications, things like that.
So
It never finished
as
product.
you sit here, you don't know how many iterations of that report you sent to the state.
There was one finished product, so no. Because
I'm not asking about the final report.
Okay.
You said there were many versions.
No, there were times where I had questions and would ask for clarification of something,
How
of the
many
state.
times did you
But
send a report to the state?
I couldn't tell you off the top of my head. Maybe a couple times, maybe 2, 3 times.
As you sit here, do you know when you sent them?
No, I would have to look at,
Would reviewing your invoice refresh your recollection about either how many or when you sent?
it might, yes.
Judge, may I approach the witness?
You may.
I'm showing you, Ms. Rosica, a copy of what's titled invoice. It's Bates stamped at the bottom. It's 3 pages. It's Bates stamped
Okay.
pages 3357, 3358, and 3359. Can you take a look at that?
Sure. Okay.
Does that refresh your recollection about how many versions of the report you sent to the state?
Judge, I would just object at this time to the characterization of it as version. She's testified there's been 1 report with regard to certain
Can you
corrections.
speak up a little bit? I can't hear.
Court reporter can't hear you.
I would object to the form of the question.
So the court reporter could not hear the basis for your objection.
Form of the question, Your Honor.
All right, so where are we going with this?
There's a discovery obligation to turn over all reports if they're,
This is a bench trial. You take up discovery obligations with me outside the trial. How is this relevant to her testimony other than how many versions? How is this going to affect my ruling in some way?
if there are other versions, Judge, we would like to see them.
Okay, well, that's something that we bring up when we're not in open court during testimony. So the objection is sustained.
You can put that down.
Okay.
Have you been paid more than the $7,850 that you billed in May of 2021?
No.
Do you expect to be or will you be paid more for your testimony?
I don't know. I would hope I would be compensated for the time I'm spending here in this trial.
Is it your understanding that you will be paid for your testimony?
I'm going to submit for it, if that's what you're asking. I have not discussed with the state's attorney's office payment, but I will submit for my time, yes.
You submitted an invoice in May of 2021,
I did.
and you came here to testify.
I did.
What is your agreement with the state about your being paid to be here today?
I have not discussed payment with them relative to my testimony here.
What invoice do you anticipate submitting to them?
What do you mean, what invoice? I don't understand what you're asking me.
How much will you be asking to be paid for your testimony time?
How much? I have no idea. I'd have to do the math.
What is the rate that you will be charging them?
This time I was paid at $200 an hour.
Is that the same rate that you expect to be paid for your testimony time during the trial?
I would hope, but I don't know. Because again, I have not discussed that with the state's attorney's office.
Judge, if I could have a few minutes.
Actually, no. Well, you can have more than a few minutes. It's now 10 minutes after 12, and we are going to take a recess until 1:30.
Judge, you want all these back?
Pardon
Do
me?
these all go back to you?
Give that back to council.
And the feed has been cut, but we heard the judge say right at the tail end there that they're planning to take their lunch recess until 1:30, so an hour and 20 minutes from this point. I have sort of scheduled to break this live stream up based on the morning and the afternoon because the last few days they've taken this nearly hour and a half lunch, so rather than just leave a live stream up for an hour and a half with nothing, I would just make a new live stream. And then those of you that wish to join in, you know to expect it around 1:30, wherever you're watching, our website, our Facebook page, our YouTube channel. And specifically for YouTube, I'll go ahead and make that event after I end this one. So you'll even be able to click the alert me when this starts piece if you so desire. Not too much to recap for you. It is once again a continuation of the state's fourth witness, the DCFS expert, as they have brought her in for to discuss procedures within the Department of Children and Family Services. She began her testimony on day one, on Monday evening, the fourth of, obviously, 4 witnesses called at that time. Continued yesterday afternoon. They spent the morning figuring out a documentation discrepancy, and now here we are, the first half of day 3. She's still on the stand, still being cross-examined, and that cross-examination not over. So they will pick that up following their roughly hour and a half lunch break, and we will pick up the live stream right along with it. I hope to see everyone back here just before 1:30 as we prepare to continue to stream this trial of 2 former DCFS workers and the accusation of child endangerment as it relates to the death of a 5-year-old from 2019. Until that next live stream, I'm Chip Brewster. Hope to see you guys in a little bit.